Hi, everyone. Thank you for joining us for this summit, which is co-hosted by the Juvenile Justice Initiative and the Illinois Collaboration on Youth. I'm very grateful to have such a fantastic lineup of speakers and panelists. So we're just going to jump straight into the program, and I'm going to start by introducing our MC for the day, JJI's board chair, Herschella Conyers.
Good afternoon, everyone, and thank you so much for being here. As Luis says, we've got a lot of ground to cover. I think this is exciting, and thank you all for attending. And I'm not going to waste any time with this. So at this point, let me introduce to you Douglas Keith. Mr. Keith is counsel in the Brennan Center's democracy program, where he works primarily to promote fair, diverse, and impartial courts. So with that, Douglas, please get us started.
Thank you so much for having me. Allow me to get my presentation up on the screen. Hopefully you all are seeing my slides now.
Yes.
As you just heard, my name is Doug Keith. I'm counsel at the Brennan Center for Justice. And really excited to be a part of what I think is a really important conversation. So at the Brennan Center, just to give you where I'm coming from now, we think the research around remote proceedings shows there's real reason to push back against courts that aren't being thoughtful in their implementation of video proceedings. But to start, I want to give you a sense of sort of how we reached that conclusion, because we didn't really come into this work thinking that's where we were going to end up. So at the onset of the pandemic, just like you all did, we saw courts across the country moving quickly to hold more proceedings remotely. They dipped their toes in, they expanded to doing more and more work remotely, to the point where we saw the first ever trial fully by video take place in Texas last year. And to give you a sense of how big a revolution this was, there was a survey again in Texas, but a similar experience across the country. Judges, prosecutors, defense attorneys were surveyed by Professor Jenny Turner, and a quarter of them had participated in some kind of remote criminal proceeding before the pandemic. But once the pandemic started, 92% of them had. So just a really dramatic change in how the justice system operated. So as this revolution took place, my team tried to figure out, so what do we know about these proceedings? What does the research tell us, and what doesn't it about how defendants are going to be affected, as well as other justice system participants? And we had three key takeaways I want to talk you through today. One, there is important research showing that defendants get worse outcomes when they're required to appear on video for some hearings, at least. Two, there are some common theories as to why this is, and supporting evidence for those. That can maybe help us think through what the big problems are and how we can respond to them. And three, many judges just love remote proceedings. They want them to be the new normal. So it's going to be essential to figure out how to push back and when to push back. Because again, not every remote proceeding raises the same concerns, but some raise some pretty serious ones. So let's get started. Let's dig into the research on the outcomes. There are three studies I want to lift up to start. First, this study out of Chicago, which many of you may be familiar with, some of you may not. But in the early 2000s, Chicago started using video for most felony bail hearings, with the defendant appearing remotely, everyone else was appearing in person. A 2008 study analyzed more than 600,000 felony bail hearings and found that judges imposed substantially higher bail amounts when proceedings occurred over video. And I want to be clear about just how big these differences were, because they weren't small. After video was introduced, the average bond amount for video cases rose by 51%. So if you had $10,000 set previously, now it was $15,000. And for some offenses, it rose as much as 90%. So pretty much doubled for some offenses. There were no statistically significant changes in bail amounts for cases that were still held in person. And this graph that you're seeing right now, it shows that these disparities, they lasted over time. This wasn't just a quick blip when video started. This lasted for years. And as some of you may know, the epilogue here is that Cook County was so shaken by this data and the litigation that came with it that they voluntarily returned those very offenses to in-person hearings and stopped doing video altogether. So the next study I want to talk about comes from the immigration space. 2015 study by UCLA professor Ingrid Eagley found that detained respondents were significantly more likely to be deported when their proceedings occurred over video conference. 83% of video hearings resulted in removal as compared to 80% of in-person hearings. This may seem like a small difference, but it was a sample of 150,000 cases and was statistically significant. So what this means is that while the percentages or differences are small, thousands of people were removed from their communities because of the format that was used for their proceeding. And this chart is just showing you sort of two different samples that the professor used, both of which were statistically significant. And the last thing I want to talk to you about some pandemic era research. There are real obstacles to studying outcomes during the pandemic. There's just so many other things that were going on that could have been affecting outcomes that it's hard to really pinpoint what the impact of remote proceedings was. But there have been a number of surveys that are pretty telling. In one survey of justice system stakeholders in Texas, 72% of defense attorneys said that online proceedings were tending to lead to less favorable outcomes for defendants, whereas only about 5% of prosecutors and judges agreed with that statement. So when we're thinking about this question and all the changes to policy and rules that courts are making right now, it's just so essential to remember that many judges, they have a clear perspective here, and it is not one that is shared by many defenders. So why might video result in worse outcomes? This is sort of the important question. And again, I want to first point you back to Professor Eagley's study about deportation proceedings, because she really dug into this question quantitatively and found some interesting things for our purposes. So first, the problem wasn't that video was affecting how judges were behaving, but that it was affecting how the detained person was able to interact with the proceeding. She found a general disengagement with the process when hearings took place by video. She used 3 metrics to find this. So people who participated in person were 35% more likely to obtain counsel. They were 6% more likely to apply for a form of relief called voluntary departure. And they were 90% more likely to apply for a form of relief that would have allowed them to remain in the country. In interviews that Eagley conducted, she heard that respondents faced logistical hurdles with the advanced preparation that comes with video proceedings and needing to submit materials through remote systems. There were challenges communicating between clients and attorneys effectively and confidentially. And respondents often just found it difficult to understand what was happening during video proceedings. Many of the people who had to participate remotely by video, they said that these appearances were unfair and just didn't feel like a real day in court. The author of the Chicago bail studies also had some theories as to why bail was so much higher for video participants. One, they said the picture quality and video setup gave the appearance that the defendant just wasn't making eye contact with the court in a way that wouldn't have happened inside the courtroom. The defendant's remote location also made it difficult for the attorney to gather information in advance of the hearing or consult with the client in the middle of the hearing. The researchers also raised the question of whether some aspect of appearing in person affects a person's believability, which is something that the research supports, and I'll talk about now. So I want to sort of break down what seem to be the key challenges posed by remote proceedings. Studying this and talking with the stakeholders over the past year and a half, we see there's some agreement as to what the biggest concerns are. So first, I want to talk about this credibility question. And there's a number of studies related to witness testimony supporting the idea that people testifying remotely might be viewed as less credible. Much of the research here is actually focused on youth. The rest of the research I'm talking about is not limited to youth. But here, studies found that youth testifying remotely were viewed as less accurate, less believable, less consistent than when they gave the same testimony in person. One study found that youth testifying by video were assessed as older than they actually were. It's important to note that these studies were largely about youth testifying as victims or witnesses rather than defendants. But back in the immigration space, the Federal Government Accountability Office surveyed immigration courts, and in half the courts they studied, judges said that video affected their credibility determinations of respondents in those proceedings, who were effectively in the position of defendants. One judge said that he couldn't really hear the facts over the video and didn't find the respondent's testimony believable. But once the person appeared in person, he was able to hear, and the judge changed his credibility determination. Another judge said that he couldn't actually perceive a respondent's cognitive disability by video, but that it was clearly evident when that person testified in person. And so again, the judge changed his credibility determination. That Texas survey I mentioned found pretty wide agreement among judges, prosecutors, and defense attorneys that the online setting makes it difficult for parties to assess and, where necessary, challenge witness accounts or credibility. And this is one area where the courts during the pandemic have shown some concern and found that some witness testimony taking place remotely may not satisfy confrontation clause requirements. The next category of problems, and this is one that I think people really find most concerning, or many of the stakeholders we've spoken to, is the impact of remote proceedings on attorney-client communication. Across studies, researchers heard that the altered attorney-client communication in the video environment could be harming defendants. In the study by the Stanford Criminal Justice Center, which is another one of the pandemic era surveys, 66% of respondents said that the move to virtual hurt attorney-client communication. 81% said it made it harder to have confidential communication. 94% said it made it harder to build relationships with their clients. And I mean, you all attending this event probably have a much better sense of this than I do. But what we were often hearing is that courts have not, while they sort of think that they've taken the steps to make this communication possible, it is often very difficult, particularly in the middle of hearings, for attorneys and clients to have that very quick form of communication that they're able to have in the courtroom, either because the systems do not exist for attorneys to step out of the virtual space and have a one-on-one conversation with their client, because they do exist and there's concerns that they are not confidential, or because they do exist and it's just seen as too disruptive to the virtual proceeding to ask for permission to actually take advantage of that tool. And so we heard about this concern over and over again. I, of course, want to mention tech difficulties. We are all familiar with that over the course of the past year, but they can pose serious problems in the context of remote proceedings. 2017 study funded by the DOJ, again, about the immigration space. And sort of just to give you an idea, one of the reasons we keep going back to the immigration space and the research is that they have used remote proceedings extensively for many years in a way that other justice system participants haven't used it as extensively. So that's why a lot of the good research is here. But so that study funded by the DOJ found that tech difficulties in the immigration context rose to the level of due process violations in some instances. Again, in that Stanford study, 78% of attorneys reported poor audio at some point during the pandemic, 60% reported poor video. And finally, I just want to talk about the digital divide. The courts are adopting these tools with certain expectations about how community members will be able to use them. And those expectations may not fully appreciate the extent of the digital divide today. FCC data about the digital divide found that while 4% of all Americans and 9% of rural Americans lack access to broadband, for example, 26% of people in the Black rural South and 18% of people on tribal lands lack such access. So it's clear that there are still significant communities across this country and within most states that have disparate access to this technology. Interestingly, there's not differences in smartphone ownership, but that raises an important question, which is, are these tools optimized for smartphone use? Sort of, is a judge anticipating that someone appearing remotely is going to be sitting in front of a laptop in front of a plain background in a way that's easy for the judge to see? And does that conflict with the reality in which someone's actually, at school and using their smartphone to access this proceeding in a hallway? We have to ask whether courts are being realistic about the technology that people have access to and what their familiarity with that technology is. To be sure, because I know that a lot of people we've spoken with have said there are benefits to remote proceedings, I want to make clear that we're not saying every hearing needs to be in person. This has been a really key question for our advocacy, because sometimes when courts hear resistance to their plans for remote proceedings, they assume the resistance is total and they can just sort of shut down to any outside perspectives. But there's real nuance here that courts need to hear. All the research suggests to us is that there are questions to ask about whether a particular remote proceeding could cause problems for a client. Is this a substantive hearing? Does the hearing involve credibility determination for my client or my witness? Will attorney-client communication in the middle of the hearing be beneficial? Is there evidence being introduced? None of the research that I've seen suggests that every status conference has to be in person. This revolution that has taken place in the courts, it presents a real opportunity to make the justice system less disruptive and less demanding on the people who are subjected to it. Our research just tells us that there needs to be care taken when figuring out what's really an opportunity and what looks like an opportunity but could actually make things worse in the name of efficiency and convenience. And again, there might be consensus on these points. The Texas study showed us that judges, prosecutors, and defense attorneys all identified initial appearances, status hearings, and other things that may feel more procedural as appropriate for remote proceedings. So this may be an area where the courts, practitioners, and affected communities can really work together. Courts have also suggested that there's evidence that remote proceedings are actually helping defendants. So one data point that we've heard in a number of jurisdictions is that appearance rates are improving. In an Ohio survey, juvenile judges surveyed reported that appearance rates slightly increased because parents no longer needed to miss work and defendants no longer needed to secure transportation to the courthouse. And we've heard similar reports from Michigan about housing court proceedings and appearance rates there. But again, it's going to be really important to think about what questions we're asking here and whether they're the right ones. Appearance and default rates are not the only thing we care about. What's the ultimate outcome here? How are youth experiencing these proceedings? How are people, being threatened with eviction from their home experiencing these proceedings? If the outcomes are better, that's great. But so far, the focus in the research has really just been on appearance rates. So to wrap up, I just want to say one reason it's so important you all are having this conversation is, to some degree, this is the new normal. We are hearing from judges across the country that they just love how remote proceedings have worked, and they are either thinking about how they can change the rules and policies to allow for more remote proceedings going forward, or they've already done so. And many jurisdictions have already changed their rules and procedures and even lobbied state legislatures to change laws to allow for more remote procedures. To be sure, the research leaves open lots of questions about which hearings might be less concerning and which ones are more concerning. Our view right now is that the research that does exist counsels for caution and thinking really hard about what's a real opportunity and what we need to do to protect our communities. So with that, I'm going to wrap up here and happy to talk more as the conversation continues.